Everybody obviously wants to avoid litigation, right? And it's the worst case scenario. What are just some of the basic fundamental things, Lee, on just how to avoid litigation? Just basic behaviors as landmen. I mean, landmen do a lot of B2B work, business to business discussions, contract negotiations. If you're a field landman, you're dealing with the public, you're dealing with landowners, you're dealing with sophisticated land and mineral owners. Just what are some of the just kind of basic things you need to do to avoid getting into litigation?
Well, I think sometimes, especially if you're in like lease negotiation or even right of way negotiation, that's is making sure where you're at as far as an agent position. A lot of times land brokers get in trouble when they try to be the middleman, buying their own name and flip, which that's fine. That's a business risk that they take. But another situation where you have is especially in Louisiana, you have an undisclosed agent and an undisclosed agency situation where you behalf of a principal that doesn't disclose his agency or the actual principal. He's on the hook for that until that principal becomes notified. So that's one way that that you can get pulled into a lawsuit or take steps to avoid it, is make sure that you're disclosing your status as an agent. And if you're not, for a business reason, at least understand the risk that becomes along with that and how to mitigate that. And one way to mitigate it is to have yourself be named as an additional insured on the E&O for the agent. Another way to mitigate that is to disclose the agency at the proper time. When you get past the letter of intent, you get to the binding reps and warranty stages.
Let's talk about what that looks like in the real world, Lee. So say I'm a field landman, and I've been hired by a company to go out and negotiate leases with a mineral owner. And I'm doing it, my client wants to be stealth, right? They don't want the public knowing that, XYZ oil is active in this area. What's required of the landman to properly give that notice to the owner to protect them from the situation you were explaining?
Well, they can disclose their agency without necessarily disclosing the principal. That modifies their exposure a little bit. I need to go back and look at that.
So
But
what's the agency mean? So it's like I'm Brent Broussard, landman for Dudley Land Company, leasing on behalf of a client of ours in the oil and gas business that's looking to put a project together. Is that sufficient notice, or is that enough or not enough?
so that would be a situation of a disclosed agency and an undisclosed agent. I think in both cases, the agent can be held liable, and the difference is if the principal is notified, or if they're no, I'm sorry, if the person is made aware of who the principal's identity. Then if you have a disclosed agency, undisclosed agent, then I think that shifts the liability. Whereas I'm not sure that it does if you have both an undisclosed agency and an undisclosed principal.
Okay. I
Um,
guess
so in that situation, I guess what you've got to do is, if you are, let's say you're actually taking the name, taking the lease in the name of, say Dudley Leasing Company, and then of course with the intention of assigning it to XYZ Oil Company. Uh, I don't know that avoiding litigation, like I said, the only way to really avoid it is to not be a landman, but to mitigate that risk is you've got pretty healthy indemnity provisions in that assignment to XYZ Oil Company. And realistically, given the leverage that they have, those are something that would probably need to be worked out ahead of time.
Yeah. Okay. So it really just boils down to clear communication, have good documentation, make sure that your assignments, out of whatever your entity into the eventual purchaser, clean and well reviewed and documented by counsel, and so on and so forth. I guess that just boils down to not doing shoddy land work. Don't be shady. Be on the up and up. Don't lie to the public. Don't misrepresent who you're representing. Um, One of the things we see a lot, it kind of goes down to ethics. Really, if you're don't be snaky and you won't get sued, kind of thing.
Right. Well, so that was actually not to dominate the response here, but that was one of the next things that we were going to bring up is Brian and I talked about don't be shady, don't be crooked, don't. I had one case where the landman was claiming, or the plaintiff was claiming that the right of way agreement did greater rights than it did. The substance of the agreement was not it was I guess the focus, what it meant, not really the formation or the execution, that they were deposing the landowner who granted that pipeline right away. And we were talking about how, uh, what was meeting of the minds type thing, who was there, what we are talking about, what was discussed. And this was a right of way agreement that was executed. Being from Louisiana, you probably know, in notarial or authentic form. It was before a notary and two witnesses, which is a little bit different than the subscribing witness situation here in Texas. It's got to be executed in front of the notary, in front of the two witnesses, all at the same time. This one was authenticated or in authentic form with the notary and two witnesses, and that's relevant because it establishes the authenticity if you ever have to go to court over it. Maybe not admissibility, but you don't have to have somebody come in and attest so much as this document is this. I recognize these signatures because it's authenticated, because it's done in front of a notary and two witnesses. This one was done in front of a notary and two witnesses. So I asked the guy, does he remember the witness or the notary and all that? He said, no. He said, we signed it in the booth at the truck stop. It was just me and the broker. And so what happened is him and the brokers, he signed it. The guy takes the agreement back to his office, notarizes it, gets two witnesses to sign off on it, and it rolls with a fake authentic form, and it really is considered filing a false record. The judge was not real receptive to that bit of information. We ended up getting their preliminary injunction denied and zero. They didn't do it themselves. That wasn't even the focus of the lawsuit. They could have done it without doing all that, but that garnered such significant bad will. So don't be shady. I guess that's a long way of saying don't be
Don't
shady.
take shortcut. I mean, you see that in Louisiana a lot when you do have to have those witnesses. It can be inconvenient to do that.
I've made one resign before in front of me.
Yeah,
They
it can
signed
be
it,
very
brought it in. I
inconvenient.
was like, no, you're going to have to sign it in front of me.
Yeah.
So
Well, especially attorneys in Louisiana carry a heavy burden as far as it's not easy to go get to be a notary public in Louisiana, right? Obviously, as an attorney, I guess you have statewide authority to notarize, but outside of that, it has to be someone from within the parish, and there's heavy testing to be a notary. It's not just like in Texas where you apply for it and send in a check. But I guess that all goes back to make sure you're following the procedures. Make sure you understand in the state, as a layman, the state you're working, what those notarial requirements are, and follow them to the T. We always did subscribing witness acknowledgments in Louisiana, and those were sufficient, right? And everything was documented. Our landman would be the subscribing witness, and then they would bring that to notary publics. We provide proof of identity and all that stuff to clear it up and try to be on the up and up, and do things the right way. So that's certainly it.
Well, before we leave this topic, there's another thing I think that is very important for trying to avoid litigation, and I think that's about process. And so having good checks and balances throughout as you go, not only with your own work product, but your office, writ large sort of thing. Even as attorneys, we do this. An examining attorney might draft a title opinion after reviewing instruments, but then it will go into review. And another attorney will then look at their flow chart, look at the comments that are being drafted, see that there's agreement with the reviewer. Maybe even have a meeting where you discuss the various issues. But having those kinds of systems in place where you're making sure that you're crossing T's, dotting I's, I think that goes a long way to protect you from any kinds of issues down the road.